Everyone can simply speak in their language of preference. Everyone will be able to hear you. And when you hear someone speaking in a language you don't understand, you will also hear the interpreter speaking in your language of preference. So I'm going to repeat this now in Spanish. Esta reunión se ofrece de manera bilingüe para asegurar justicia lingüística, lo cual significa que todos pueden escuchar y participar en esta reunión en el idioma que más dominan. Ya hemos prendido la función de interpretación. Entonces pueden dar clic en el globo terráqueo situado en la parte inferior de la pantalla y ahí seleccionar el idioma que dominan mejor. Si están conectados por teléfono o por tableta, primero seleccionarán los 3 puntos de más opciones para poder seleccionar interpretación. Y durante la reunión, las personas de habla inglesa deben hablar en inglés y los intérpretes se expresarán en tiempo real en español. Los hispanohablantes deben hablar en español y los intérpretes lo harán en tiempo real en inglés. Interpreters are typically 3 to 4 seconds behind the speaker, so please remember to pause before responding to another speaker. Also, please state your name when you begin speaking. The interpreters may write in the chat, please slow down or please speak up, and we will need the support of the meeting hosts to read those messages aloud so that the speaker is made aware. Los intérpretes típicamente están 3 a 4 segundos detrás del orador. Entonces, por favor, pausa antes de responder a otra persona. Por favor, también anuncia su nombre antes de comenzar a hablar. Esto nos permite interpretar todo. Podremos escribir en el chat en algún momento, por favor, hablar más lento, por favor, hablar más fuerte, etcétera. Y necesitaremos el apoyo de los anfitriones para interrumpir al orador y leer nuestros mensajes. So, the interpretation channels are on. If you can hear me right now in Spanish using the interpretation, please, I hope it's working. I'm not sure if we can see thumbs up or if we can, if people want to write in the chat that if you can hear me, but hopefully you're able to hear me now in the Spanish channel. And I'm going to speak in Spanish just to see if someone in the English channel can hear me properly. Entonces, estoy hablando ahora, probando el sonido, hablando en español, pero si los que están en el canal de inglés me escuchan bien, muy bien. Parece que están respondiendo que sí me escuchan. All right, well, we're all set. Thank you for letting us take some time. And you can assign me to an interpretation channel now.
Okay. Great, thank you so much. All right, thanks so much everybody for joining us today. My name's Katie Witchett. I'm a senior staff attorney at Legal Aid at Work. And I'm here with Shazzy Kamali, who is also a staff attorney in the Work and Family team. So we're going to be talking about paid time off and accommodations for people who are pregnant, new parents, and family caregivers, focusing on all of the important rights that families need to know about, but also about rights that have changed in the last year so that everybody can be up to date. Legal Aid at Work, as background, is a nonprofit organization that's been around for over 100 years now. Give me 1 second. We're having one issue. Okay, everybody should be able to chat now. My apologies. So Legal Aid at Work, we're a nonprofit. What we focus on is the workplace rights of working families. So to make sure that everybody can have a job, can be well, can take care of themselves, and earn an income. And to do that, we have a bunch of different strategies. So part of it is doing outreach and education like this to make sure that folks and healthcare providers and other service providers who provide support to families know about their rights at work. But a big part of it also involves providing one-on-one support to workers and technical assistance to healthcare providers and social service providers. So at the end, we'll share our helpline number, which is a number where anybody across the state, whether they're pregnant or a family caregiver or have their own health condition, or a social worker who has a question for a patient, can call us, reach a voicemail, and then we'll get back to them within a day or two and provide free, confidential legal advice. And, for a lot of folks, just getting that advice to know, okay, I can take this many weeks off is all that they need. Other times we represent people, we write letters to their employer, file their cases in court. So it's really just about doing what we can to make sure that people are able to access the rights that they're entitled to. And another part of what we do is just making sure that these laws match what families actually need. And one of the things that you might see today is that some of these laws aren't exactly what we'd hope that they would be. But every year, generally, they get a little bit better to provide stronger support to families. So just to start out with kind of a path of what we'll be talking about today, these are some of the updates that we want to flag. So we'll cover all of the basic rights, but we'll be focusing on these updates as well. So one is that starting in 2025, everyone is going to be entitled to a lot more income from paid family leave and state disability insurance, so close to their regular income, so that they don't have to take a pay cut in order to access those programs and take time off. A second is that paid sick days was improved last year so that folks can take 5 paid sick days in a year. So that's the floor. There was also a bill to add time off for people who experience different types of reproductive losses. And then we'll cover some recent updates as well, which are stronger lactation accommodations and laws that have allowed more people to have the right to take time off for their health and to support their family. So there are 4 main categories of rights that we'll be talking about, which is the right to take time off and know that your job will be safe, the right to be free from discrimination, the right to get paid if you're taking that time off from work, and then rights to changes at work for pregnancy and lactation. And we're dividing it up into these categories, just so folks can kind of think through what are those important rights and how do they apply to the patients and families that I'm supporting. And just as a note, we'll have the chat open throughout. So if you have any questions, always feel free to drop them in the chat. At the end of this, we'll be reserving a good chunk of time as well to go over questions. And then I also just wanted to make the note that we really appreciate all of you being here today to learn about these rights for your patients and the families that you support. Access to paid leave is associated with really great health outcomes for families. Children are more likely to get their well baby visits and vaccinations. It's associated with lowering rates of admitting folks in nursing homes and all kinds of good maternal health benefits. So that's some of the reasons that we're really passionate about these rights, and we're glad that you recognize that these things are important to the families that you support. So first, I'm going to start with pregnancy discrimination. So this is the most basic one that I think we'll come across today. And it is that employers are not allowed to discriminate against folks at work for being pregnant. So what that means is that they're not allowed to treat people who are pregnant worse. So that applies to hiring. So employers can't choose not to hire somebody based on their pregnancy. And it also means that employers are not allowed to fire folks for being pregnant, to cut their pay or benefits, or to pass them up for a promotion or to demote them. And an important part of this is that employers are not allowed to force somebody onto pregnancy leave. That is something that we see come up, unfortunately, where an employer will say, oh, you're pregnant, just go on to leave. This work is too hard. But if somebody wants to keep working and they're able to keep working, they have the right to do that. So it's a really important protection. And then finally, employers aren't allowed to harass their employees based on their pregnancy or create a hostile work environment for them. So that could be making negative comments about their pregnancy or other behavior that makes it so it's just not possible for them to work in that environment. So in addition to the right to not be harassed at work, pregnant workers also have the right to reasonable accommodations, which is just to changes at work that they need for their health or for a health condition that is related to pregnancy or childbirth. So what accommodations are, they can really be anything, and they depend very much on what somebody's specific job is. So if they have to bend over to take pizzas in and out of an oven, if that's something that is uncomfortable for them or dangerous, they can ask for a note saying that they aren't able to do that. But the one thing is that to have the right to pregnancy accommodations at work, folks they need to be advised by a healthcare provider. And employers frequently will ask for a note saying that the accommodation is at the advice of a healthcare provider. This right applies to any employee who has an employer with at least 5 employees. So that means it applies to people who are new, people who are part-time. It's just if somebody is pregnant and they are working, they have the right to accommodations that are advised by their healthcare provider. And here we have some advice kind of on how this works in practice. And so the main point is that it's helpful to talk to a patient about their specific work and what they're dealing with, so that you can make sure to provide a note or suggest a note that is specific to their needs. Because employers do need to provide these accommodations, but the one risk is that if the person is no longer able to perform their job at all, and there aren't any positions they can be transferred into, then it can create a situation where the employee needs to take leave from work. And a lot of people want to keep working while they're pregnant. They need that income. So talking with that person about what they need in their job is really important. So for an example, we have one worker, Mariana, and she does security work. So for instance, in a note that you're writing for her, you might want to say that she needs a break, but she is able to continue to patrol the building, and she is able to walk around between those breaks. And with that, I'm going to pass it to Shazzy to talk about leave.
Hi, everyone. Welcome. Thanks for spending your Valentine's Day with us. I just want to quickly address the last question in the chat from Shoko. Yeah, so in terms of, and the question was if a healthcare provider needs to advise on a work accommodation, mental health providers, or if mental health providers are included, and the answer is yes, any licensed medical provider can provide a medical certification supporting a request for a pregnancy accommodation. And Lupe, I also see your question. We have a slide later on about paid sick leave days, so we can work in the answer to that question when we talk about that. And also feel free to raise it in the Q&A later on as well. Okay, so let's talk about these 2 key concepts: job protected time off work and wage replacement while you're off work. It's really important to keep these 2 separate in your mind when you're trying to understand how leave works for pregnancy and for parents. Generally, colloquially, we use the blanket term maternity leave or parental leave. And it's important to understand that both of these components are essential for parental leave, but they work separately and they kind of come from different laws and they're in different programs. So firstly, I want to talk about job protection. That's the first concept that was on the previous slide. So job protection comes from a specific law called, for pregnancy, comes from a specific law, the Pregnancy Disability Leave Law. And that establishes that employers have to give their employees up to 4 months of job protected leave when their employee is disabled by pregnancy, childbirth, or a related condition. If an employer is not able to provide a pregnancy accommodation to an employee, then pregnancy disability leave would apply to the kind of leave that the employee would need. So, for example, if you have a patient who needs a pregnancy accommodation at work, but the nature of their work is that they're not able to do their job with the accommodation, or the employer is unable to give them the accommodation because it's like inherent in their position, then they would start their pregnancy disability leave. Unlike other types of leave that we'll talk about, pregnancy disability leave is pretty broad. It applies to all employers who have at least 5 employees, and it doesn't matter how long the employee has been working there, or how many hours they work, if they're part-time, full-time, or anything like that. Um, so pregnancy disability leave can be used for prenatal care. So it can be used for appointments and appointments. So for example, if someone has a pregnancy where they need regular, let's say like monthly appointments, they can use their pregnancy disability leave to get the time off to go to that appointment. It can also take pregnancy disability leave intermittently, so it doesn't have to be a whole chunk of time. It can be 1 day off a week or 2 weeks off chunks. Um, so pregnancy disability leave, the law does not require employers to pay their employees. It requires them to give their employees the time off and keep their job for them, and also continue their health insurance benefits if they're receiving health insurance benefits through their employer. Um, and it can continue after the baby's birth. Um, so an uncomplicated pregnancy would be considered disability. Sorry, Katie, can you go back real quick? Thank you. Uh, earlier on the previous slide, we talked about how pregnancy disability leave is up to 4 months. That's not a default. So you all, as care providers, would provide the medical certification that establishes when someone would be disabled by pregnancy, childbirth, or related medical condition. And so generally, I don't have to tell you, you all are the experts and you know that generally for an uncomplicated pregnancy with no complications or risk factors, a disability is at least 4 weeks before the due date, and then 6 to 8 weeks after delivery. So 6 weeks for vaginal, 8 weeks for C-section. And so, yeah, but it can be extended after birth, for example, for postpartum conditions, or if you as the medical provider see that your patient needs to stop working before the 4 weeks before the due date because they're unable to work or because there is a risk to them or their baby, you can write that note. And as long as it doesn't exceed 4 months total pregnancy disability leave, then their employer has to give them that.
Yeah, and I just want to chime in to help with some of the questions in the chat that were related to what Shazzy was just talking about. So one of the really great things about pregnancy disability leave is so that time exists only for the purpose of the person who is pregnant's health. So it can be up to 4 months if somebody needs to be off that long for their health, but as you said, usually it's less. But what that means, because it's only time for somebody's health, is that even if you decide to work up until the day before you have your baby, it doesn't mean that you're going to get more time off total, because it's only when you need that time off for your health. So it's specifically designed to help make sure that people take the time off that they need for their health and that they're not focused on saving that time to have more after. There are separate laws that allow people to take time after to be with their baby. Back to you.
Thanks, Katie. Yeah, so state disability insurance. So earlier I talked about how the pregnancy disability leave law does not require employers to pay their employees when they're on pregnancy disability leave. It just requires employers to provide the time off. So the way that people are able to take pregnancy disability leave is by applying to the Employment Development Department, which is a California state agency for the state disability insurance benefit. So this is a form of wage replacement that you have to apply for with the EDD in order to get paid when you're on your leave. So to get the pregnancy disability leave, you would need to ask your employer and you would need to provide them with a medical note. And then once you've confirmed that and when your leave starts, then you can apply for state disability insurance to get paid. So partial wage replacement when you're unable to work because of your health. Again, disability insurance is for when you're on pregnancy disability leave, and also generally if you're unable to work due to disability. It includes pregnancy and recovery after childbirth. And you can still receive state disability insurance if you are laid off or terminated. So this is an example of how state disability insurance or wage replacement is separate from job protection or the leave law entitlement, because even if you're not eligible, if you're not technically on pregnancy disability leave because you're laid off or terminated or just not working, if you're unable to work or unable to look for work because you're disabled due to pregnancy, then you can receive SDI. And the amount that you can get from SDI is 60 to 70% of your regular wages. But in 2025, that percentage will increase so that most workers will be able to get 90% of their wages through the SDI benefit. So there is a waiting period. What that means is that the first week of your leave will be unpaid. So if you're on pregnancy disability leave, the first week of your pregnancy disability leave, you will be on your SDI waiting period, which means that you will not be able to get SDI benefits for the first week of your leave. But then after that, you can get SDI benefits for up to 52 weeks. And so what that means is even though pregnancy disability leave is up to 4 months, um, this is another example of how they kind of work differently and how they have different requirements and eligibility. Pregnancy disability leave is up to 4 months. SDI is up to 52 weeks. So you can get SDI for as long as you're unable to work due to disability, as long as it's less than 52 weeks. And pregnancy disability leave is up to 4 months. Immigration status and citizenship do not matter for getting the SDI benefit. We actually have a guide on our website in English and in Spanish, uh, explaining the process for applying if you're undocumented. It's a little bit different. And we also have a slide later on in this presentation talking about it a little more. So to apply for SDI, you have to apply through the Employment Development Department. So you can do that online or through the paper mail application. So you can apply up to 49 days retroactively. What that means is that you can apply uh, 49 days after your leave started, or later with good cause. And for example, something like your employer not telling you about this benefit or not knowing you were eligible can be considered good cause. Um, in order for someone to receive SDI, as part of the application process, they will need to provide a note from a healthcare provider, from a licensed healthcare provider. So that is something that you may be asked to do or have already been asked to do and may be familiar with the process, but you have to fill that out in order for the person who's applying to get their SDI benefit. Um, yeah, so this is just kind of a summary slide. explaining everything that I was just saying. So job protected time off work and wage replacement when you're off work are separate. Job protected time off work is pregnancy disability leave, and wage replacement is the state disability insurance benefit. Um, and in order to get pregnancy disability leave, you would need to ask your employer and provide a note to them. And then also apply, in order to get paid during your leave, you would need to apply to the EDD and provide a note to them. A lot of times people think that the EDD and their employers are in communication with each other, or just providing notice to the employer or the EDD is sufficient for the other, but you need to do both. Um, so here is just like a visual explanation of how it all fits together. So state disability insurance and pregnancy disability leave. So let's look at the bottom. Pregnancy disability leave. This is the unpaid job protected time off. If someone has a quote unquote uncomplicated pregnancy, so no complications, no risk factors, um, they will be disabled by their pregnancy 4 weeks before the due date and then 6 weeks after giving birth. So that's the period of time when they're not working and they're not receiving any payment from their employer. And so they can get state disability insurance for that time period. But it is important to know that there is that 1 week waiting period, and then there'll be 9 weeks of STI benefit. And the reason it's 9 weeks here is because the total amount of time that this person is taking off through pregnancy disability leave is 10 weeks. So let's talk about an example. Angela is pregnant and she works as a cashier at a large drugstore. So her physician has put her on bed rest at 34 weeks pregnant because she has a high risk pregnancy. So is she able to get time off and pay? Yes, so she works at a large drugstore. That means that her employer has at least 5 employees, which means that she qualifies for pregnancy disability leave. And because she has been put on bed rest by her physician, she's disabled from working due to her pregnancy. So she's disabled from working, so she can receive state disability insurance. So here is what Angela needs to do in order to make sure that she's met her own obligations to be able to access this leave and this wage replacement. So she has to give her employer a note from her medical provider saying just that she's disabled from working by her pregnancy and the expected start and end date of her leave. Um, and she has to apply for state disability insurance from the EDD, and her healthcare provider will have to fill out another certification.
Thanks, Jazzy. We've got a lot of good questions coming in to address a few, and others we can talk about later at the end. So to certify somebody as qualifying for state disability insurance with the EDD does have a specific form that must be filled out, and it requires more information than somebody has to give to their employer. So really those should be two separate things, a certification to the EDD and then a note to the employer, because the note to the employer doesn't really need to have very much information, just that it's a health condition related to somebody's pregnancy and the dates that they need off from work. And so that disability time that we were talking about, pregnancy disability leave, so the job protection and the state disability insurance pay. So that's all just specifically about the person who is pregnant and gives birth's health. But now we're moving on to the part where we're talking about the other ways to take time off. So as Shazzy mentioned, we're lucky that we're in California where people have these rights to leave. And the way it's set up is so people do have those rights for their health. And then there's a separate set of rights that they have to time off that can be used for bonding with a new child. And it can also be used to take care of a seriously ill family member. So I'm going to start off by talking about the California Family Rights Act. And it's similar to the FMLA. I know a lot of people have heard about the FMLA, but it's a little bit better. And so generally, I'd suggest people just think about the California Family Rights Act instead of the FMLA, because generally they'll overlap. So the FMLA won't actually give anybody any additional time, But the California Family Rights Act will cover some people that aren't actually covered by the FMLA. So what it does is it allows somebody to take 12 weeks off from work where their job will be safe. They can use these 12 weeks within 1 year of having a child or adopting or fostering a child. Both parents can use it. If the child has more than 2 parents, the parents can also still use it. Additionally, people can also use this time to take care of a family member who is seriously ill. And that can be a parent, a spouse, a domestic partner, child, grandparent, grandchild, sibling, parent-in-law, or as of a more recent change in the law, it can be an additional one person that that employee chooses to name in that year. So if somebody's just really close with their cousin or their neighbor, or let's say somebody's best friend has a premature baby and that person wants to take time off to care for their new niece or nephew, even if it's not someone who's related by blood, they can designate that person. So it can be used for all of these different reasons, but it's only 12 weeks within 1 year. And so in addition to bond with the baby or to take care of a seriously ill family member, it can also be used for somebody's own serious health when it's a condition other than pregnancy, or to address some needs that arise from a family member being deployed overseas. So while it seems odd that it excludes pregnancy, the reason it excludes pregnancy-related health conditions are so that somebody can save this time and use it after pregnancy disability leave. So even once they recover, they can take 12 weeks to bond with their baby. So that's the really important thing to keep in mind. So after somebody's healthcare provider has said, okay, you're ready to go back to work, or after somebody has used 4 months of pregnancy disability leave, then they can start using these 12 weeks of California Family Rights Act time so that they can still bond with their baby, even if they needed time for their own health. So unfortunately, it does have stricter qualifications than pregnancy disability leave does. So to qualify, somebody has to have been working for their employer for 1 year or more. Their employer has to have at least 5 employees. So that's something that's changed in the last couple of years. And they have to have worked at least 1,250 hours in the prior year for that employer. And that comes out to being about 25 hours per week. So I have the 5+ employees highlighted because this only started in 2021. So I think more and more employers are aware of it, but sometimes there are still employers out there that are smaller that might not be aware that they are covered by this and that they have to let people take this time off to care for family or to bond with a new baby. And in those circumstances, we found just sharing a fact sheet, directing somebody to a government website can be helpful. But this, the 5+ employees, is kind of the main thing that makes this different than the FMLA. There's some others, but this is the main thing. FMLA only covers employers with 50+ employees. So the California Family Rights Act applies to a lot more workers. So California Family Rights Act gives somebody the right to take time off with their benefits continued, knowing that their job is safe. But there's a separate program called paid family leave that allows you to get paid during that time. So it's called paid family leave, but in my mind, I always think of it as paid family insurance because it's not the right to take time off. It's just how you get paid. Just like how earlier we were talking about pregnancy disability leave with state disability insurance for income. For caregiving or bonding, it's California Family Rights Act leave, and then paid family leave for income. So what it does is it allows somebody to get partial income when they are bonding with a new child. Again, it can be adopted or foster child too. When they are caring for a seriously ill family member, or for a need related to military exigencies overseas. And this for bonding, again, can only be used within 1 year of the child being born or joining their home, whichever occurs first. I will note designated family members are not currently covered by paid family leave. So if somebody's taking time off to care for a niece or a nephew, their job might be safe, but they won't be able to get paid during that time. Although there's a bill moving forward this year that will hopefully fix that. So paid family leave offers workers 60%, 60 to 70% of their income, 60% for most workers. But starting in 2025, most people are going to get 90% of their income. For people who make over about like 80,000 a year, they'll get 70%, but for most workers, it's going to be 90% of their income. Paid family leave income can be received for up to 8 weeks per year. And again, like all of the benefits and all of the rights that we're talking about in this training today, citizenship and immigration status do not affect eligibility. So even if somebody is not a citizen, they can apply for and receive paid family leave. It is important to know that paid family leave is something that workers really pay for out of their own paycheck. So other than public employees generally, everybody in every pay stub, they'll see there's like a little deduction that says CASDI or something like that, and 1.1% of their income being taken out and put into this fund so that if there's ever a time they can't work because of their health or because they need to care for somebody, they can get income. So anyways, I think it's important to help folks realize that they're paying for this. So they really should apply for it if they qualify. They have the right to this income. It's not tied to citizenship. People can take it all at once or intermittently. So it can be broken up if, say, you're caring for someone with a reoccurring health condition or trading off caring for them with somebody else, something like that. And both parents in a bonding situation can take paid family leave at the same time or at different times. So how to apply? This is another benefit that is paid for through the EDD, the Employment Development Department. So people can apply online, and generally that's going to be quicker, but people can also apply using a paper application, and we'll talk a little bit more about that next slide. People can apply up to 41 days retroactively, so from when they started their leave, but importantly, they can apply later if there's good reason. So if, for instance, somebody's employer didn't tell them that paid family leave existed and they didn't know that paid family leave was a thing, they can apply later and include a note saying, hey, I didn't know paid family leave existed. And in our experience, generally that will be considered good cause and they will be able to get their benefits. So if you know new parents who could have applied and haven't in the last few years, I generally encourage them to, because it could be very helpful for them. There's no medical certification that's required for baby bonding, but if somebody is taking time off to care for a seriously ill family member, then their healthcare provider will need to fill out a paid family leave certification for the EDD. And so it will include some detailed information, but again, that detailed information goes to the EDD. It doesn't go to the employer. So for folks who are undocumented, to get disability insurance or paid family leave, we recommend that they apply with a paper application. And the reason we recommend that is that by filing with a paper application, they can avoid promising that they have their own Social Security number. And we have a guide, and we'll share the link that provides more detailed steps that they can take to apply for paid family leave or state disability insurance and make sure that the EDD has the information that it needs to pay them. So they can apply leaving the Social Security number part blank and then instead attach proof of their wages in a letter explaining their income. They might need to follow up with the EDD after that, but folks who are undocumented can and do qualify and should be applying to get the benefits that they pay for. So one thing I want to touch on briefly, and this is only relevant for people who work in San Francisco, is just that if somebody works in San Francisco, they can qualify to get their paid family leave supplemented up to 100% of their pay. So there are some more detailed qualifications, and you'll have this slide that you can look back at. But if you're ever talking with a parent who works in San Francisco, it's worth making them aware of this, because they might be able to get 100% of their wages when they're taking that time to bond. And I will pass it back to Shazzy.
Thanks, Katie. So this is another summary slide just explaining how all of these things work together, and there's going to be a bunch of examples after this that I think may answer some of the questions, but again, we'll have time at the end for more questions as well, or to address the questions that are already in the chat. So job protected, again, like going back to that thing that I keep mentioning, which is that job protected time off work and wage replacement while you're off work are separate. In order to get pregnancy disability leave or California Family Rights Act bonding leave, you have to ask your employer, you have to give them notice, and you also may, depending on pregnancy disability leave or the type of California Family Rights Act leave that you're taking, need to provide a medical note. And then when you are on an eligible leave, you can apply to the EDD to get paid either state disability insurance when you're on pregnancy disability leave or paid family leave when you're on bonding leave. And so paid family leave is 8 weeks. California Family Rights Act is 12 weeks. So there will be 4 unpaid weeks if someone wants to take the full California Family Rights Act, either bonding or caregiving leave. So this is how it all fits together. So if this is an example that outlines what leave and wage replacement and all those things will look like for someone who gives birth and is eligible to take CFRA or CFRA, same thing, bonding leave after they recovered from their disability, pregnancy disability. So let's start from the bottom. You'll see it says pregnancy disability leave. So this is a person who doesn't have any risk factors or complications in their pregnancy. They're going to start their leave 4 weeks before the due date, and then their pregnancy disability leave will end when they've recovered from their pregnancy. And because it's an uncomplicated pregnancy, it will take them 6 weeks to recover. And so after they've recovered from that, after they've finished their pregnancy disability leave, that is when they can start their California Family Rights Act 12 weeks of bonding leave. And so that bottom part next to the little lock symbol, that is a summary of all of their job protected time off. And in order to get these leaves, they have to tell their employer ahead of time. And the best way to do that would be, and we have some like sample letters on our website, is just for the worker to say, I'm taking my pregnancy disability leave from this day to this day and my California Family Rights Act bonding leave from this day to this day. When they're on pregnancy disability leave, they can apply for state disability insurance. There is a 1-week waiting period. So when this person is on pregnancy disability leave for those 10 weeks, the 4 weeks before the due date and the 6 weeks after, they can get 9 of those 10 weeks paid through SDI at a rate of 60 to 70% of their wages. And again, in 2025, that will go up to 90. But then 1 week will be a waiting period where they won't be able to get SDI. And then once they are no longer disabled due to pregnancy or childbirth, and they're not on pregnancy disability leave anymore, and they've transitioned into their California Family Rights Act bonding leave, then they can get 8 weeks of paid family leave benefits through EDD. And sorry, could you just go back really quick? Previously, Katie was talking about the law that only applies to San Francisco employees. So here you can see that if someone is getting paid family leave for those 8 weeks when they're on bonding leave, then they may be eligible to get the additional percentage that they're not getting replaced through SDI, so the 30 to 40% of their wages paid through their employer if they're eligible and they work in San Francisco. So this is a visual that explains what it looks like for parents who don't give birth. So if someone is not pregnant, but they become a parent, then And they're eligible for CFRA leave. So remember, they have to have worked for their employer for at least a year, worked 1,250 hours in the year prior, and they need to, their employer needs to have at least 5 employees. Then they would be able to get 12 weeks off to bond with their new baby, and they can get 8 of those 12 weeks paid through the paid family leave EDD benefit. And if they're eligible and work in San Francisco, they may be able to get full wage replacement through their employer.
And I just wanted to chime in to say this is a really good, important one that's very underutilized. So we really encourage you to share this information with folks. There are a lot of new parents who aren't taking that time off to bond with their baby, and it might be because they think they'll lose their job or they think they won't have the income that they need to do it. But they can get 60 to 70% of their income from paid family leave. And as we said, starting in 2025, they will also be able to get up to 90% of their income. So we're really hoping that more parents will feel empowered to take time off to bond with their new baby.
Thanks, Katie. So here is an example. So adding on to the previous example, Angela has her baby. So 6 weeks after her baby is born, her physician clears her to return to work and certifies that she's no longer disabled due to her pregnancy or her childbirth. So can she take more leave with pay? Yes, maybe. If she qualifies for CFRA, California Family Rights Act leave, then she may be able to get more leave after she's recovered from pregnancy and no longer needs time off for that. So if her employer has 5+ employees, if she's worked there at least a year, and she worked 1,250 hours in the year before her leave, then she can take 12 more weeks of leave through the California Family Rights Act, CFRA. And so if she is eligible, if she is taking time off from work or not working because she's bonding with her baby, then she can apply to the EDD for the paid family leave benefit. And the reason you see /PPLO is because PPLO stands for Paid Parental Leave Ordinance, and that is the San Francisco law that we have been mentioning. It's really important to make sure that people know that there are things that you need to affirmatively do as a worker in order to have access to, in order to be protected by the Pregnancy Disability Leave and California Family Rights Act leave laws, and also to get the wage replacement from the EDD. So Angela will need to give her employer a note saying she's taking her California Family Rights Act leave. And she'll need to communicate when she wants her leave to start and when she expects to return. She's also going to need to apply for a paid family leave. So for people who are receiving SDI for pregnancy-related disabilities, sometimes the EDD will automatically send them a notice asking them like, hey, we noticed that you were getting state disability insurance for pregnancy. Do you want to start your paid family leave? You may be eligible if you gave birth and are now bonding with the baby. And again, if she works in San Francisco, she can ask her employer for supplemental compensation under the Paid Parental Leave Ordinance. Here's another example. This is for Terry, whose granddaughter was born at 24 weeks and needs to spend time in the NICU. So Terry has been working full-time for a large construction company as a welder for 12 years. So what kind of paid leave is Terry able to access? So if Terry's granddaughter has a serious health condition and requires care, which it seems like would be the case because they need to spend time in the NICU, then that means that Terry is able to take time off through the California Family Rights Act to help care for their granddaughter. So because Terry is caring for a seriously ill grandchild, he can also apply to the EDD to access income through paid family leave for 8 weeks. In order to make sure that Terry does all the things that they need to do, they will need to give their employer a note stating that they're taking this CFRA, California Family Rights Act leave to care for their seriously ill grandchild, and when they expect the leave to start and end. Employers are allowed to ask for a medical certification in these circumstances, but it can be just from the licensed medical provider who provides care for the seriously ill person, just stating that that person is seriously ill and they need the worker, in this case Terry, to care for them. And then Terry will also need to apply for paid family leave from the EDD. And Terry's granddaughter's healthcare provider will need to fill out a separate certification for the EDD. The EDD has like a very specific form that they want healthcare providers to fill out for all claims.
Thanks, Jazzy. So with that, we're going to move to a couple of other laws that can be really important for family caregivers and specifically for new parents. So one of those is that people do have the right to lactation accommodations at work. First, an employer must have a written policy. It's a newer law in California, but they are required to. So it can be helpful to suggest that folks ask their employer for their policy. I think there are employers out there who don't have one. So it's also important to know what rights people have. And the first is that they have the right to reasonable break time. So there's no set limit on how much time somebody can take to pump. But they are allowed to take more time than their normal rest breaks. And the reason there's not a specific time is in recognition that it can be different for everybody. So the law wants to make sure that if somebody needs time to pump, they can have that time. And then secondly, in addition to the time, they also need to provide a place to pump. And that place cannot be a bathroom. It needs to be somewhere that is safe, that's clean, that is free of hazardous materials, and then also that has a place to put a pump, has a place that the person can sit, has access to electricity, refrigeration, and running water nearby. So some of these things like refrigeration, could be met with a cooler, or electricity could be battery packs. So depending on somebody's work situation, it might look a little bit different, but employers do have the responsibility to provide these accommodations. And if folks have questions, we work with some great partners who are real pros on this. And no matter the work situation, whether it's a field or anything you can think of, would have suggestions for a way to make it so that somebody can pump and have the privacy that they need and feel safe. So in addition to lactation accommodations, workers in California, fortunately, have the right to paid sick days. So previously, basically all workers across the state had the right to earn and use 3 paid sick days in a year, which can be used for somebody's own health, for reasons related to domestic violence or sexual assault, or to take care of a family member or help a family member with preventative care. But as you can imagine, 3 days is not enough. That's like one bad cold. And in a family where maybe there's a couple of kids and preventative appointments, 3 days disappear like that. So we're very glad that last year, a new law was passed that allows folks to take 5 paid sick days in a year. So workers can use them after 90 days of employment, and they earn these paid hours over time. So for every 30 hours that somebody works, they earn 1 hour of paid sick leave. Again, immigration status does not affect somebody's ability to use these paid sick days. And they can be used for somebody's own medical needs and also to take care of family or to deal with preventative care needs or take steps to secure safety from domestic violence or sexual assault. And employers are not allowed to require a medical note in order to let somebody use these paid sick days. One protection, in addition, that we want to talk about is it is specific to San Francisco, but it's called the Family Friendly Workplace Ordinance, And what it does is it allows people to get accommodations. So changes at work, like we described earlier for pregnancy, for the purpose of taking care of family, whether it's a seriously ill family member or a child. So the family-friendly workplace ordinance empowers parents to maybe like request a slightly adjusted schedule for pickup, or to be able to have a phone with them at work, or to work remotely on certain days, things like that, changes to their job to help them care for their family. And their employers are required to provide it unless they can show that it would be extremely difficult for them to do that. So this is a newer law, and it's only for people working in San Francisco, but we think it's a really important one because taking care of family doesn't mean that people necessarily always just need time off from work. There might be changes to their work that allow them to keep going in and doing everything that they would otherwise. So if people are working in San Francisco, it's a good thing to let them know about. And if you have any more questions, of course, you're welcome to reach out to us. And we have a whole training that's just on the family-friendly workplace ordinance. Another important recent law is one that was passed this last year to let people take time off for reproductive loss. And so what it does is it allows someone to take up to 5 days off unpaid, but with their job protected when a reproductive loss occurs. And it can be used repeatedly for up to 20 days in 1 year. So reproductive loss includes a failed adoption, a miscarriage, a stillbirth, an unsuccessful assisted reproduction, or a failed surrogacy. And importantly, it applies to anybody who would have been a parent or guardian, except for the event that happened. So it's not just for the person who is pregnant and experiences a miscarriage. Anybody who would have been a parent of that child is also able to take this time. It applies to folks who have an employer with at least 5 employees and who have worked for that employer for at least 30 days. So it covers part-time employees. You don't need like a full year of tenure. It's just those 30 days of work. For people who experience a miscarriage or other health conditions related to pregnancy, they will likely also qualify for pregnancy disability leave, so may have a way to get more time off if they need it. Or if a healthcare provider thinks they need additional time, they could, as I said, take pregnancy disability leave and potentially access state disability insurance for income. So there are some existing protections when somebody needs more than 5 days. And we're happy to talk about specific circumstances with individuals who call us. But to just have these 5 days is a step forward and an important protection for families. And with that, I'm going to pass it to Shazzy to cover some of our other materials, and then we'll have time for questions.
Yeah, thanks, Katie. So this is just quickly, just so you're aware that there are other rights and protections specifically for establishing leave and accommodations for survivors of domestic violence, stalking, or sexual assault, and then also leave for enrolling in school or participating in school activities for parents. We have some resources on our website that explain all of these things in more detail, and I just want to highlight a few of those so that you know what to look for and where they live. So we have fact sheets in English, Spanish, and Chinese on leave and benefits for dads, for LGBTQ plus parents, foster parents, and for parents generally and pregnant people. We also have, like we mentioned earlier, a guide for undocumented workers on applying for SDI and PFL. This image that you see is our roadmap for pregnancy and people who are working and pregnant. And that is available in English and Spanish and Chinese. We also have video resources on rights for pregnant and parenting workers. These are available in English, Spanish, Mandarin, Cantonese, Vietnamese, Tagalog, Korean, Arabic, Armenian, Punjabi, and Farsi. And these are all on our YouTube page and also on our website, legalaid@work.org/WF. And there is that URL is in this presentation.
And we're really excited about these. Please share them out. They are shorter than this training, directed to be something that families can understand. So anyways, they're new, lots of languages. Please feel free to share.
We also have wanted to like highlight these resources that are specifically for healthcare providers. So one is a fact sheet on workplace rights for NICU parents who have children in the NICU. And also we have a sample letter for healthcare providers. Sharon just linked one in the chat, so that's one that we have. And yeah. Here is our number for the Work and Family Helpline. That's our website. And yeah, thanks so much for listening. We can jump into the questions now.
Yeah, thanks everybody. So that helpline, anybody across the state, whether they just want to know how much leave they can have, how they can qualify for these rights, if they're having an issue with an employer, or you have a patient and you're not totally sure if they qualify or want to be able to give them more information, please feel free to call at any time. And we will be sending a follow-up email with the recorded training and then also some of these materials. And we have a lot of these as online materials, but we also have paper copies of some of them available that people can request if they'd like those to like hand out to the parents that they're working with generally. And with that, we can dig into the questions a little bit. I know there's a lot, so we probably won't be able to answer all of them, but if we can't answer your question in the moment, we'll follow up and email you and provide you with an answer if it's not something that we've talked about already in the training. So let's see. And I'll also invite Sharon, our wonderful program director of Work and Family. If you see questions that you think we should address, feel free to highlight those. So I see one great question is about the timing of requesting California Family Rights Act leave. So that's those 12 weeks of job protected time that can be used to bond or to take care of a family member who has a serious health condition, or it can be used for somebody's own serious health condition. Employers can require workers to provide 30 days of notice if they are aware of the need for leave coming up. So if they know when their baby's due date will be, they can provide like an anticipated start date. Or if they know, this is the time when I'm going to, travel to a different state to help my older parent move into an assisted living situation, something like that, they should give their employer a note in advance. But if it's something that somebody doesn't have notice of, then that is fine, and they should just give notice as soon as they can. We all know that medical emergencies come up, and if somebody provides notice within a reasonable amount of time, so as soon as they're able to, generally we recommend, then they should still be okay. And it's not a requirement that notice is provided in writing, but the reason we keep pointing to it and suggesting it is it's just a lot easier to have something to point to if something goes on later on to say like, look, employer, I texted you, this was the text, or, this was the email, or I handed you this paper that said it. It can just be helpful to have a record to make sure nobody forgets, and also to be able to prove that you had that conversation if any kind of issue comes up.
I see some questions about the state average wage. So the percentage that you get through of wage replacement that you get for SDI and PFL is not based on the state average wage. It's based on your own wages in something that's called the base period. So that's the 5 to 18 months before you apply and before you want your benefits to start. So it's a 16 to 70% of your own wages, not the state average.
That's a great question. And so the state average is going to come into play in 2025, where people will still get the percentage of their own wages, but it's just folks who are making up to 70% of the state average weekly wage. That's how we're defining lower and middle income earners. Those are the ones who will get 90% of their income instead of 70% of their income. So that's something you can look up online, and I'm sure we'll be sure to share that information out, and the EDD will as well when it gets closer to that time, because it tends to change a little bit. So I see one good question in the chat. Can multiple people qualify for paid leave per sick person? And does each person who qualifies get up to 8 weeks? Or do the people caring for the sick person need to share the 8 weeks? So that's a great question. So these rights to leave, they are based on like the worker, not on the recipient. So multiple people can take up to 12 weeks of California Family Rights Act leave to care for one person if they are providing care. And multiple people can apply for paid family leave to get those 8 weeks of income to care for the same ill person. So it could be multiple people like taking like shifts over time. So, you know, it could cover months and months with multiple family members taking time off and applying for paid family leave. But if people are applying for like the same weeks in time, there is a limitation that people, multiple people caring for one person cannot receive paid family leave income for like that same hour. So if, say, an older adult is ill and they have 3 kids, their 3 kids could apply for paid family leave and get it for the same time if they're taking different 8-hour shifts throughout the day. It's just not for those same exact hours. So if somebody has like specific questions about a circumstance, they're welcome to reach out to us, but generally multiple people can apply and get that support. Okay, another good question I'm seeing is, so if a mom applied for paid family leave after 6 weeks of PDL, but a mental health provider believes that she has postpartum depression and writes a note to certify, can the mom extend her PDL and start her paid family leave later? And the answer is yes. So that's a really important thing to be aware of. So while it's typically 6 weeks for somebody to recover from a vaginal birth, if there aren't complications, it can be extended longer if somebody needs it for their health. And if it's extended longer, they can keep being covered by pregnancy disability leave, which protects their job, and getting state disability insurance longer, which enables them to save that paid family leave bonding time for later on. So because they're using that time that's for their health as long as they can and using that first, that allows them to have a longer period of paid time total. So if somebody is still struggling with their health and they do need additional time to recover, it is helpful to give them a note saying that they need time for their health and to certify for their state disability insurance. Because if they start using their bonding time up, they might, you know, use that bonding time up while they're recovering and use their paid family leave income while they're recovering. And then they might not be able to use it later once they've actually recovered from their health condition. And it's an important thing to remember too, especially given the fact that not everybody will qualify for the California Family Rights Act. So that job protection for bonding, like we talked about, only covers employers that have at least 5 employees and people who have been at their employer for 1 year and worked at least 1,250 hours within a year. So if somebody is a new employee or they're very part-time, their job, and they have a baby, their job will only be safe as long as their healthcare provider says that they need time off for their health. So it can just be important to talk with them, see how they're doing, and see if maybe they do need additional time that is for their health. Because if they need additional time for their health, they can take that off and have their job be safe and continue to get state disability insurance income. Okay. Lots of good questions. Shazzy, do you want to pick one and jump in?
Sure. So I'll just answer the most recent one. If the person who has to certify postpartum depression has to be a psychiatrist, it can be any licensed medical provider.
Yeah, and there's a list that we can provide too of like who is authorized to certify for state disability insurance. But generally, the idea is that if you as a provider feel that you are qualified to say that this person needs additional time off for their health, and you're on this list of providers, which does include like OBGYNs, then you're able to certify. So many good questions. Let's see. All right, we have time for one more. And I'll provide a list too of who can certify for time off from work, because it is a slightly different list, which I know is confusing, but there are more people who can certify for the right to time off than can certify for receiving state disability insurance benefits.
So I see this question about if a person's off work for postpartum depression and the symptoms have not resolved by 4 months, is their job still protected? So the law doesn't require employers to keep a person's job for longer than 4 months for pregnancy disability leave, but there may be other laws that may apply. And that would maybe a situation where you could contact the helpline for more specific advice.
Yeah, absolutely. So at that point, somebody could choose to switch to their bonding leave, use those 12 weeks of time. And, you know, it is a bummer that they have to use their bonding leave during a time when they're not feeling fully recovered, but that's one option that people can do. And then, like Shazzy noted, when people need an extended time off, there are other laws that can give them the ability to take some additional time, but it's not as black and white as the ones that we've talked about. It ends up in a space where it's more of like dependent on the person and the job and what's happening. So for extended leaves, totally recommend that they give us a call and we can talk about it and help give advice to give them their best shot at making sure that they can keep their job and continue to get income. I'm seeing questions about paid family leave benefits. We can also include some like links to the Employment Development Department's website in our follow-up email. So anyways, thanks everybody so much for joining us for a little more than an hour this afternoon and for all of your great questions. And we will follow up to provide these materials and to provide answers to questions too. If it would be helpful, you think, for us to do like a training for your organization or for like other folks, also feel free to reach out. And this is something that we're happy to do. So thanks everybody and happy Valentine's Day.